This is a Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. Host here on the Professional Edge. The topic we're talking about is the 411 on probate avoidance. Talked about bank accounts having a POD, adding a person as a joint account holder, or even leaving that account in the individual's name and drafting a financial power of attorney so that way they have access to it in case the account holder becomes mentally incompetent or frail. Then the agent can come in, transact business on that bank account or any other financial account, and it doesn't subject to the claims of the principal or the agent. We don't confuse those two on basically allowing the agent's creditors to attach the principal's money. So again, if you're adding people to your bank accounts to avoid probate court process, there's a downside risk. Also, if you add a person to a brokerage account, you risk losing a step up in basis for a portion of that asset. And then also the same thing on brokerage accounts. So people want to have access to that. They throw their children's names on that account. Well, the downside risk is that you expose that to the claims of creditors of your child. And the biggest potential creditor is going to be your ex-spouse. And then also in a car wreck, car accident of that child that's on that account. But the bigger exposure is probably going to be the tax exposure for not getting a full step up in basis to fair market value date of death. That right there, if you don't understand that nomenclature and understand the process in which that transacts, that right there is enough to give our office a call at 404-250-9798. That number again, 404-250-9798. So it's not just probate avoidance, it's also avoiding paying the IRS unnecessary tax dollars. That's the other thing we try and do is minimize the taxes. We got to pay the IRS for our listeners here on the Professional Edge. And one great thing which we have put up and offered to our listeners here on the Professional Edge is the bundle. It is EMC Echo Mary Charlie thebundle.com. Go check it out. It's where we combine and properly plan your estate. We do your income tax planning, and we also review your investments to make sure that they are going to go to the right person at the right time in the right amount. Okay, so getting back onto the probate avoidance, okay, we have beneficiary designations. So certain things, you got that last will and testament, they are not going to be controlled by that last will and testament. Okay, so we already learned that a payable on death designation is going to supersede whatever you have in your estate planning documents, whether that's a trust or whether that's a will. So we got to be very cognizant of your beneficiary designations. One key other point on a beneficiary designation is going to be insurance. So life insurance has a beneficiary designation. So whatever you put on that line, let's say you leave 50% to your spouse and 50% to your children in equal shares. Well, guess what? Your last will and testament can say, I leave everything to my beautiful surviving spouse. Guess what? That life insurance is only going to go 50% to your beautiful spouse. The other 50% is going to go to the children in equal shares. So again, the beneficiary designation on life insurance supersedes whatever you have in your estate planning document. So who coordinates that? Well, your estate planning attorney should, and if they didn't review who the beneficiary designation on that life insurance is, then it's up for grabs. Only the life insurance agent is going to know who that beneficiary is. So that's when you look at them and say, wow, okay, I'm the surviving spouse. I thought I was to get the entire life insurance proceeds. Because when we met with the attorney, we had I love you wills, which says, I love you, you get everything. And if I die before you do, then you get everything. And the attorney says, yep, that's the way it was going to be. So the attorney calls the insurance agent. Their insurance agent says, well, that's not what I have. I have a beneficiary designation, which says 50% to spouse and 50% to kids in equal shares. And the attorney sort of scratches his head and he goes, well, you know what? Sorry to tell you this, but the life insurance is going to be 50% to you and then 50% to the kids in equal shares. And the life insurance agent is going to say, well, I'm not an estate planning attorney. I would have done it different. If I would have known that everything was supposed to go to the surviving spouse, then I would have updated the beneficiary designation. But I'm not licensed as a lawyer to give estate planning advice. So you see the disconnect that can happen on this very simple thing. And I've seen it time and time again, because the estate planning attorney only drafts the documents. They don't check the beneficiary designations on things, and things go awry because the I love you will, you would think that that controls on all the property, and that is including life insurance, should go to the surviving spouse. But gotcha. The life insurance was directed a different way, and the beneficiary designation supersedes whatever that last will and testament. So all in that last will and testament does not mean all, because there's certain things that are not controlled by the document. That also includes a trust. That's why being a tax attorney, a CPA, certified financial planner, all these things need to be checked if you're going to have an effective estate plan. I've done it enough times, 3,000 plus times, to make sure the gotchas don't get you. So if that's your type of planning that you want, give our office a call at 404-250-9798. That number again, 404-250-9798. The other alternative, you can go to EMC, that is Echo Mary Charlie, thebundle.com. Again, emcthebundle.com, and we put these three things together: your estate planning documents, we review your tax strategies, and then we also review your portfolio. Great bargain. That's how to introduce yourself to us. So back to the 411 on probate avoidance. Well, let's say that we have a life insurance policy and we want it to be controlled by how the plan of distribution is in the will. Well, then we can always say that the primary beneficiary on that life insurance is the estate of the insured. So now it gets picked up by that last will and testament. And guess what? If the last will and testament says all to my surviving spouse, then the surviving spouse is going to get all of those life insurance proceeds. So that beneficiary designation on a very liquid in payout, because it could be $500,000, could be $1 million life insurance benefit that gets paid out in a lump sum, you definitely want to structure that properly with your estate plan. Now, the other item, which is normally a client's largest financial asset, is their retirement account, their 401k, their 403b, or if they retired and rolled it over to a self-directed IRA, the same thing applies. It's a qualified account. Now, being the largest financial asset, you would think that that would be incorporated into a will or a trust. Well, no. The answer is, again, it's controlled by the beneficiary designation. So, all right, we have $1 million 401k. We're going to roll it into a self-directed IRA. So now we're going to name the beneficiary on that IRA. Now, I probably will suspect that 95% of our listeners here on the Professional Edge that are married have named their spouse individually as their primary beneficiary. Look at each other and just nod if you've done it. Okay. Now, the contingent beneficiary is probably the kids in equal shares. Nod if you think that's what's happened. You're all covered, right? Okay. Let's walk through a scenario. And I've seen it time and time again. And it scares me. And that's why I want to stress this. Well, you did the beneficiary designation to the spouse. That's fine. It's going to avoid probate court. That's what we've talked about, the 411 on probate avoidance. So the surviving spouse comes in with the death certificate, goes to the custodian of the IRA and says, look, principal person has passed away. I'm the named beneficiary. I'm their spouse. Roll it over to me. I don't pay tax. All done. Perfect. Excellent. Probate avoidance 101. Now, what happens when the spouse gets on down the road 3 years, 4 years, 5 years, and they meet someone, Mr. Right or Mrs. Right, whichever one passed away first. We're going to say that the husband passed away, the wife found Romeo, or Romeo found her. That's the more like it scenario. So Romeo comes in and he says, my financial guy is soup to nuts, got it all figured out. He's amazing. We got to go see him. And the beautiful bride says, okay, that's fine. Well, the conversation goes on down the road, and the wife ends up converting and transferring her accounts over to Romeo's advisor or stockbroker. Well, the stockbroker drafts the accounts, and you know what? The primary beneficiary on that account is normally the spouse by default, so they get all the paperwork ready. No one really checks and balances. The estate plan attorney is over here because he's drafted the will, and he's all good. They have I love you wills, and here we go again. So Romeo becomes the primary beneficiary on this IRA. And lo and behold, the spouse gets ill, and she passes away 2 years after the marriage. And guess what? Romeo walks in with the wife's death certificate to his stockbroker and says, I'm the primary beneficiary, and this IRA is now mine, because that's the way this works. Now, the kids of that first marriage are knocking on the attorney's door and says, hold on, now let's talk about something. Because you drafted mom and dad's will, and it was everything to each other. And then when the survivor passed away, it was equally to us. He goes, yep, that's exactly what it says in the document. Yep, you're right, 100%. And the kids go, well, wait a minute. Dad had an IRA that when he passed, it went to mom. And then mom passed, and you're telling me that this IRA is going to go to Romeo? It doesn't go to us? And attorney just looks at him in a blank stare. Guess what? It's going to go to Romeo, because the beneficiary designation supersedes whatever's in the estate planning document. So that right there is a wake-up call. It's the largest financial asset that people have, and they don't take it responsible enough to protect, to make sure the kids are going to inherit that. Tune in to the next session on the 411 for probate avoidance to see how we're going to protect the kids to make sure and guarantee that they get dad's IRA and Romeo doesn't get it. My name's C. Todd, tax attorney, CPA, certified financial planner. Thanks for listening to The Professional Edge.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.